Good Tuesday morning, everyone. Welcome. Thank you for joining us here for the Mackinac Center's Virtual Planning for Life workshop. I'm Joe Milligan. I'm a Director of Strategic Partnerships here at the Mackinac Center, coming to you from my home office. And we have a great conversation here today that I have the privilege of moderating around the subject of estate planning and ensuring that your legacy reflects your values. And we hope that you'll come away feeling more equipped, whether you are just beginning this process or whether you have all your plans in line and you just need to make updates, and whatever the case might be. We hope that you'll come away feeling more equipped to do so. We have a great conversation between some important guests here today. But first, a quick matter of housekeeping. I want to point out that on the right-hand side of your screen, there is a Q&A box. If at any point in the conversation you have a question that you'd like the presenters to answer, go ahead and put those in there, and we'll do our best to make sure that we get to as many of those as possible later on in the presentation. To kick things off, I want to hand things over to Mackinac Center President Joe Lehman for a few words. Joe is an engineer by training. He joined the Mackinac Center in 1995. He became president in 1998. Joe has trained over 600 public policy executives around the world in strategic leadership. Joe has overseen a number of free market policy victories right here in Michigan with the Mackinac Center, and he and his wife are the founders of Midland County Habitat for Humanity. I would add that 2020, the year of COVID, because of Joe's leadership, we are uniquely positioned as an organization to be as effective as we have ever been as a result of his guidance and leadership. So, Joe, I hand the microphone over to you.
Okay, thank you very much, Joe, and welcome to all the Mackinac Center friends and supporters who are joining us. You have a great program today, and it's an experiment for us because it's our first time not doing this event in person. Usually our Planning for Life seminars are in person, but there's just been so much interest since we haven't been able to do them in person. We decided to take it online, so thank you for signing up, and you'll hear from great Mackinac Center friends, Greg Demers and Lawson Bader today, and we'll go, I think, even into some subjects we've never covered before. And our usual format for these is for me to give an update on some of the fun and great things the Mackinac Center is working on, probably the reasons you're interested in the Mackinac Center in the first place. You'll, as a Mackinac Center supporter, you'll be really happy to know that our work has been recognized by our peers around the country. The State Policy Network, which is a group of more than 50 state-based think tanks, has actually given the Mackinac Center 3 awards. One was for a marketing campaign where we actually poked a little fun at Governor Whitmer's executive orders by producing cartoons that showed where her executive orders on the pandemic lockdown made no sense. Our cartoons would depict somebody walking on a golf course with a golf club, which was illegal under the order, and it would show somebody walking on a golf course with a walking stick, which was legal for some reason. And we did notice that when we would publish a cartoon, the governor would sometimes quietly change her executive orders to something not as easy to make fun of. We also were recognized by the awarding of the ED Prize, the Education Prize, for our idea that during this time when the public schools are having such a hard time fulfilling their basic function, they've got more challenges than before, and in some cases they're not even providing instruction. We think that the money taxpayers pay to educate kids ought to follow those kids. So I go to the parents, no matter what, even if the school, especially if the schools aren't able to do their duty. So your help makes that possible. Your help makes it possible to work with think tanks around the country in helping us navigate this crisis of the pandemic and the lockdowns. We actually worked successfully with Governor Whitmer in relaxing some laws related to the practice of medicine that made it easier for care providers to help people in need. in the first few days and weeks of the pandemic. Although some of our priorities have had to shift because crisis, our research continues apace. You may have seen our corporate welfare study where we went back to the 1980s, examining Michigan corporate welfare program, and we found that the government has subsidized companies to create jobs at about $600,000 per job per year. It's outrageous, and we show again we have another more intellectual ammunition that shows that these programs don't work. And we were joined by the former chairman of the President's Council of Economic Advisors, Kevin Hassett, who praised our work. But some of the work that's most relevant right now is directly related to Governor Whitmer's extremely stringent and unlimited executive orders in trying to fight the pandemic. The Mackinac Center's case was heard at the Michigan Supreme Court 3 weeks ago today, where the justices were almost unprecedented in giving us more than 3.5 hours to explain why the governor's use of this authority is unconstitutional, because it simply has no limit in time. There's no legislative input. The emergency can go on for as long as the governor says there is an emergency, with no legal way to check that. So we and our clients were in court making the case that people need their rights. We have elected representatives who must play a role, and it's time to restore those rights. I know that some of you support the Mackinac Center because you're interested in labor policy, and you're interested in helping us inform workers of their rights under the law to join or not join a union. After the Janus decision at the U.S. Supreme Court in 2018, we can report that our estimate is that 16% of unionized government workers have exercised their new rights to not support a union. And this is because we launched, it's not entirely because, but due in large part to a massive effort that you have helped us fuel to educate workers across the country. And we patterned it after educating workers in Michigan after we helped Michigan become a right to work state. We said it worked in Michigan. We helped more than 20% of the people get out of their union who wanted to get out. And why don't we do it around the country now that the Janus decision says it applies to government workers everywhere? So before I turn it back over to Joe, I want to thank those of you supporters who were aware that I actually had COVID. And so I can tell you that it's good to be careful. You don't want COVID, but made a full recovery, and the Mackinac Center didn't miss a step. And thank you for expressing your support during the time that I had to rest. So we'll turn it back over to Joe, who will introduce one of my favorite Legacy Society members.
As Joe alluded to, one of our longtime friends, Greg Demers, is our first speaker. Greg's a partner in the law firm Warner, Norcross, and Judd, LLP. He practices in the firm's Midland office. Warner has 8 offices in the state, including Southfield and Macomb County. Greg is a graduate of MSU and the George Washington University Law School. Following law school, he served as an attorney advisor to a United States tax court judge in Washington, D.C. Greg is the past president of the Northeast Michigan Estate Planning Council, and he regularly speaks to lay and professional groups on business and estate planning. So Greg, unpack that a little bit. Tell our listeners here what you do.
Thanks, Joe. Thanks for the nice introduction. As you mentioned, I'm with the Warner Norcross Law Firm, and it's a large firm, over 200 lawyers, a significant number of whom practice in the trust and estates area. And I found when I left another firm to come to Warner a few years ago, there's a luxury in being in a large firm, because you can make a large firm small, and we put together client service teams and cherish the client service relationships, but you can't make a small firm large. So Warner has the best of both worlds for me, a tight-knit group of trust and estates planning lawyers with the resources to draw on all sorts of experts in the law. The other thing I like about Warner is we're committed to Michigan. You mentioned we do have 8 offices. All of them are in the state of Michigan. So unlike some firms that spread themselves around the country, we're looking to Michigan for our growth and client service. So as you mentioned, I'm in the trust and estates practice group. I've been practicing over 35 years, over 100 estate plans a year that I prepare, and a significant amount of probate and trust administration matters. So from the client's perspective, what does this all mean? Well, the core concept we want clients to take away from our work is that when they're done with the estate planning process, they will know that no matter what happens to them during their lifetime or after their passing, there will never be any probate court involvement. And we'll get into that a little bit later in some detail. We'll assure the client that we can set all of this up without them giving up any control over what they have while they're alive. And we'll go over how those things can go awry when clients try to accomplish that on their own. And the other thing we assure our clients is that regardless of the order of deaths, we will greatly diminish or completely eliminate any death taxes that might otherwise be imposed. So there's probate avoidance with no loss of control, either lifetime or death, and also minimum or no exposure to federal estate tax. So Joe, do you want to go from there?
Yeah, thanks for that, Greg. We'll dive into some questions here to explore a little bit more about that here in just a moment. I want to bring Lawson Bader into the conversation here. Lawson is president and CEO of DonorsTrust, a public charity protecting the intent of donors who value limited government, free enterprise, and personal responsibility. Through its donor-advised fund, DonorsTrust has granted over $1.3 billion to groups in academia, public policy, the arts, civics, medical and scientific research, religion, and education. Lawson has more than 20 years of experience leading research and education groups, including the Competitive Enterprise Institute and the Mercatus Center at George Mason University. Lawson, welcome. Thank you for joining us, and talk a little bit, if you will, about DonorsTrust and the role that you play with your clients.
Thanks, Joe. So yes, as you mentioned, DonorsTrust is a nonprofit organization whose primary program is a donor-advised fund. Now, in the world of DAFs, as we call them, there are really 3 different kinds of providers. You have the commercial banks, your Fidelity, Schwab, and Vanguard, which tend to be the most common and well-known. Secondly, you have community foundations, which, as the name suggests, are limited to certain geographical spaces and tend to focus their efforts within that particular space in certain sectors. And then we have what we call the mission-driven donor-advised funds, which have specific function. DonorsTrust falls into that category. We were created 20 years ago specifically to work with self-identified conservative and libertarian donors to ensure that their intent is maintained during their lifetime, at their death, and for their legacy after death. We offer privacy in one's charitable giving if that's something that is of interest. And we really exist to ensure a revenue stream to charities that are relying primarily on non-governmental sources of income and are not really trying to expand the size and scope of government. We're a mid-size organization. We have around $450 million in assets, a very active client base. So last year we granted about $160 million to charities, about 1,400 different charities in, as you sort of gave a list of arts, religion, education, public policy, science, civics, and the like. We do have a particular specialty and a fondness for the public policy world because we believe that being charitable is not just being engaged in sort of civic life, but policy provides us the opportunity to have institutions that enable us to flourish freely and create wealth and use that for our prosperity. So that's an important piece of our DNA, and certainly Mackinac has been a generous recipient of many of our clients' largesse. So that's it.
Thanks, Lawson, for that. You had mentioned donor intent, and I know that's one of your strongest focuses. So talk for a little bit, if you will, about how our viewers can think strategically about preserving their intent with their estate plans.
That is donor intent is really an issue near and dear to my heart personally and professionally. It's really why we were created, as I mentioned. At DonorsTrust, we speak a lot about the strategic mistakes that donors make, and one of those mistakes is, frankly, trusting future generations to keep your giving going, or at least until that money runs out. A couple of things to say about that. The first is to reference a Money magazine article a few years ago, which surveyed its readers and found that 70% of wealthy families lose that wealth by the end of the second generation and 90% by the end of the third. You throw in the fact that apparently it takes a new inheritor of money 19 days to buy a new car, and you can see how there could be a challenge for what you want done with your money to support groups that matter to you. And of course, I'm really talking in this context from a charitable standpoint. If we bring that a little closer to home, there's something called O'Sullivan's Law, which is named after a British writer, John O'Sullivan, that any organization or family structure for that matter, which does not have its roots firmly entrenched in sort of free market or conservative principles, will over time drift left. I like to say, you love your children, you love your grandchildren, you want to help them with their weddings, their education, buying a house, but do they support your values and will they support the organizations that matter to you? This has been very devastating to conservative philanthropy over the last 100 years. The major private foundations of our country, Rockefeller, Pew, Carnegie, Ford, MacArthur, all were born or grew out of a pro-capitalist leaning, but in some cases that was never really written down. And those foundations now actively work against free market ideas and policy proposals, especially in the environment and healthcare and education and other areas. If we fast forward that to the last sort of 16 months, under pressure from various interest groups, those large commercial donor advised fund providers like Fidelity and Schwab are starting to refuse or to honor grant requests from their clients to organizations like the Family Research Council, the NRA, Project Veritas, a few Catholic groups, and some think tanks like my own organization, or former organization, the Competitive Enterprise Institute and the Illinois Policy Institute. So what that really is doing, in effect, is sequestering millions of dollars that would otherwise be going to conservative-oriented institutions, much to the chagrin of the original donor and wealth creator. Now, the issue is not really whether you support those groups or not. It's about philanthropic freedom and, more importantly, your ability to align your giving with your particular values. There are a couple of just steps to think about when it comes to this issue of donor intent and legacy. One, you need to define very clearly what you give to and why. You know, what are you passionate about? Be clear if you like giving publicly or privately. It needs to be put into writing. In fact, make a video recording of that intent. Decide who you're going to share it with and why. Make sure the right people sort of know that you've outlined that intent and expect it to be followed. Leave a list of favorites. I'm sure the Mackinac Center will be top on the list. Rank them according to how you support them today and maybe ones that you would even consider supporting in the future. But I'll make it obvious to you what matters and then revisit that list every year. But also make a list of the groups that you don't support, right? And why? I mean, there's groups that maybe work against your principles or they work in a certain field that just doesn't interest you. If you're not clear in what you are not wanting to support, your future heirs have nothing to react to. And then lastly, sort of focus on what we call giving while living, and then on the idea of sunsetting. It may be the most important of all. Giving while living helps your money make an impact with the causes that matter to you now. But I would also suggest limiting the charitable, and limit the life of the charitable vehicle that you're going to choose and spend that charitable capital down within 20, 25 years after your death, because that really does diminish the chances that your money will support causes or groups with which you might disagree.
So you alluded a little bit to some private foundations there earlier on. So talk to me a little bit about the donor advised fund structure and how that contrasts against private foundations and what the differences might be there.
Sure. So There are a number of differences. I think for the sake of discussion with your audience, probably you should think about four in particular. Both are obviously about building up charitable capital. They both serve that purpose. So the four would be the first, I'd say, with the deductibility. With the donor advised fund, you can actually deduct up to 60% of your adjusted gross income for cash gifts, about 30% for stock gifts, and you get fair market value when that gift is made. With a private foundation, it's about 30% for AGI with cash and 20% for stock, and you sometimes get fair market value, but not always. Secondly, and this is probably the most important, the issue of control. With a donor advised fund, you have advisory privileges on your account. You do not have legal control over your asset because you have given that and received a tax deduction in return. So you can recommend a grant, but the donor advised fund sponsor can say no. And as I've mentioned, places like Fidelity and Judd have been saying no to certain conservative organizations. With a private foundation, you are acting as a fiduciary member if you're on the board of directors, for example. So you arguably do have more of a direct vote in approving or not approving a particular grant to a certain charity. The third issue would be privacy. With any donor advised fund, you can give completely anonymous. It's your choice because, again, the gift is being made, legally speaking, from the donor advised fund provider, not from you. With a private foundation, private giving is a little harder to mask, given that generally the family that funded the foundation in the first place is more publicly known. There are disclosure rules. Both donor advised funds and foundations have to list every grantee that has received a $5,000 grant or above. A donor advised fund, however, does not have to list who made the recommendation to make that gift. It's a little more obvious with the foundation. And then lastly, that idea of intent or mission. With the donor advised fund, your intent may be upheld. It depends on the provider. With a foundation, you can probably be certain of your charitable intent while you were alive and on the board, and perhaps even throughout the second generation. But as it begins to move through those generations, you really begin to lose the influence over your intent, and we've seen that happen in so many cases. So both, Joe, should be seen as complementary. You can fund both, and we actually have many clients who do have both. We have foundations that have accounts with us that they use primarily for privacy purposes. We also have a program called the Novus Society, which sort of encourages under 40 givers. And so some of our foundation families, they open an account for their children or grandchildren as a training wheels, if you will, sort of an experiment for what it means to actually sort of manage a charitable account and make recommendations, go through that process. And so we work in those ways. So those are the key differences. There are others, but I think those are the primary ones.
So Greg, let's talk about COVID, because how can we not talk about COVID? What role is COVID playing right now in the estate planning process? Can clients meet with their attorneys right now? Just what impact is that playing right now on the relationship between attorneys and their clients and the client's ability to get some of these things done from a business standpoint?
Thanks, Joe. So let me back up a little bit. When COVID first hit and we were under the stay-at-home order, there were competing factors. Clients and prospective clients were concerned about the virus, and it made them focus on the estate plan they had or wanted to update, but generally prohibited from coming in and meeting with an attorney in person. It was especially troublesome because under Michigan law, in order to properly witness and notarize wills, trusts, powers of attorney, deeds, it requires that the witness and notary be in the presence of the person signing the document. In the presence was defined as in the same physical location with and close enough to see, hear, communicate with another individual. That was troublesome. We could meet with clients on the phone or by Zoom, discuss new or updated estate plans, but there was no mechanism for them to implement the plan because we couldn't get together physically, and Michigan law required that we be in the same room as the person signing the document. So fortunately, there was an executive order that did address this, Executive Order 2020-173, that permits for the remote witnessing and notarization of wills and trusts. So some clients, since we've loosened up our stay-at-home restrictions a bit, are coming in for office meetings, and our firm has the typical protocols in place. Questions when they arrive, masking in the common areas, social distancing. But a number of clients want to do everything from their own home and not physically leave the home, both to get their estate plan done and to get it signed properly. So under the executive order, here's what we're allowed to do now. We will complete the estate planning documents for the client, mail them or email them to the client for review, and when they're satisfied with what the documents provide, we can arrange for a virtual signing that complies with Michigan law. And the process then is we arrange a Zoom meeting for the signing. I'm on it from my home office, my paralegal from her home office, and we have an IT person that has to make a digital recording of the event. She's in Grand Rapids. So the signing starts by the clients holding up their driver's license to their camera. So they have to have a computer or iPad or another device, iPhone, that's got a camera audio feature. But they start by holding up their driver's license to the camera so we can confirm their identity. They state the city and state they're signing in. And then when we start the signing process, they're required to hold up the document they're going to sign, read the title of the document, show us the signature page, and then tilt the camera down so that when they sign it, we can remotely view them signing it. Then we're required to preserve that recording for 3 years in the case of wills, 10 years in the case of any other notarized. And the client is required to mail back the document that requires notarization the same day, put it in the mail. Or if it just simply requires witnesses, mail it back to us within 3 days from the day they signed it. So the clients will send it back, and we'll either go into the office to complete witness and notarization, or they'll send it to our houses depending on our schedule. And then we validly, so to speak, close a loop, and we know that it's compliant with Michigan law. We've probably had over 50 remote signings so far under this executive order. And, it reminds me of the saying, necessity is the mother of invention. Pre-COVID, if we would have had to see the steps required to sign a document remotely, it would have seemed daunting. But now it's second nature for elderly clients even. Go through the remote signature requirements, and my legal assistant walks them through that process. And it really doesn't take that much longer than an in-person meeting and saves them a trip to our office. Again, we can still meet now with the loosening of the rules in person. Still have a lot of clients though that prefer to do all aspects of it remotely. Any questions, Joe?
Hear that in the background, but I want to ask Lawson. Lawson, there's been so many tax changes, it seems, with tax reform in late 2017, and then the Securities Act this year, the CARES Act this year. What, if anything, has actually changed? What impact does that play in the estate planning for your clients? And then, Greg, I'm going to ask you the same question, but Lawson, if you don't mind first, let's explore that a little bit.
So again, I'm looking through the lens of sort of just the charitable benefits or the charitable relationship of some of the tax changes. So in the 2017 law, you really had 3 that had an impact on charitable giving. One was the lifetime federal estate tax exemption was essentially doubled from $5 to $10 million per taxpayer up to $20 million for joint taxpayers. Now there's some adjusted for things in there, so it's now more like 23.6 million for a couple. But the point is that fewer people will be subject to the estate tax, which can be good for charities. But it's important to know that that change sunsets in 2025. Secondly, as perhaps most people know, obviously the personal exemption was eliminated, and the standard deduction was doubled to $12,000 for single and $24,000 for married. It's had some minor effect on sort of the lower end givers. But if you are an itemizer, gifts to cash are deductible now up to 60% of your adjusted gross income. It had been 50%. Gifts of stock remain deductible at about 30%. Fast forwarding, the Securities Act, which was passed the end of December last year, really did two things. Probably something that Greg may expand more on. It eliminated the stretch IRA, and it changed the minimum age for a minimum distribution from your IRA from 70 to 72. Now, with the CARES Act, which was passed this spring, there are a couple of changes that are not necessarily known. One is that individuals who make cash contributions to charities and do not itemize can now take up to a $300 deduction. Secondly, that 60% AGI limit for charitable contributions was actually increased, at least temporarily, to 100% if gifts are made via cash, not with stock. Which really means for some taxpayers, you can literally offset up to 100% of your income in 2020 with charitable contributions. I suspect that's going to be a small subset of people who will do that, but it exists. And then lastly, the requirement for minimum distribution from your IRA in 2020 was actually suspended. So that is not applicable. The biggest change in this has really been that change of the deduction. What has happened, and this is where donor advised funds have really grown the last couple of years, is in something called bunching. So for taxpayers who perhaps were not really able to itemize anymore, depending where they live and what they give to, what they were able to do is, in our case, they'd go to the DonorTrust account and they would make a contribution of, say, $20,000 into their account, take the itemized deduction in year one, do nothing in year two, take the standard deduction, but still make grants of $10,000 to their favorite charity each year. So what that's really done is give some specific tax benefits to a certain subset of taxpayers. But more importantly, it's actually smoothed the effect of giving for charities. So if you're a charity that was expecting that $10,000, and all of a sudden your taxpayer donor made hunt, by doing this bunching, it actually provides you with that annual income, even though they're sort of going every other year. So anyway, that's just one area that DAFs have been sort of affected by some of this. But those are the basic changes affecting charities.
Sure, thanks. And Greg, same question to you, but first I want to remind our audience that if they have any questions at any point in time, please feel free to go ahead and type those in the Q&A box over on the right-hand side there. But Greg, hopefully we have the feedback issue sorted out here. And same thing, what should the audience be aware of as it pertains to tax changes this year and going back to 2017 with the big federal reforms?
The comment that I would make is November 3rd will be a telltale day. We might not know what it's telling us, but that'll be a telltale day for high net worth clients doing estate planning. Right now, the issue is that Joe Biden has said the first thing he wants to do on his first day in office is repeal all Trump tax cuts. That would include the generous estate and gift tax exemption that Lawson alluded to. And so many high net worth clients are trying to gauge what needs to be done between now and the end of the year. So if there is a sea change in Washington, they've taken advantage of the current high exemption amounts. Remember in the Bush-Gore election, I think that was in the 2010 era, we didn't know the outcome because of Florida until early December. So it doesn't mean that November 3rd or November 4th we'll know the outcome. We'll just know that if it looks like a likelihood in sea change, all the experts are saying for high net worth clients, complete any gifting you had contemplated prior to the end of the year. There was the other comment during the Bush-Gore election is, I think Bill Clinton said after the election and before the final results, the people have spoken, we just don't know what they've said. And I think the same thing is going to happen here after November 3rd. So if the Congress and the administration changes parties, there could be a dramatic decrease in the high exemption amounts. And many, many clients of mine are looking not only for the charitable techniques that Lawson mentioned for giving this year, but also giving to remote generations, children or grandchildren, in order to take advantage of the married couples exemption amount, which is in excess of $23 million. The cautionary point, though, is one of the experts said, the only thing worse than making a decision driven purely by taxes is to make a decision driven by speculation of what taxes might be. So at the end of 2011, we were concerned that the Bush tax cuts were going to expire, but John Boehner and Barack Obama cut a deal and continued them. It seems more serious this time, more polarization in the parties. And so again, if there is a change in administration and Congress becomes controlled by the Democrats, you'd be well advised to consider whether those changes could affect your personal circumstances.
Greg, I've heard you talk in the past about a revocable living trust. So first off, what is that? Is it important? Why is it important? And just how does that work?
So the Revocable Living Trust is the main estate planning document we use. It's a roadmap that says who wraps up your affairs in the event of your death and who inherits what you have. Importantly, though, with the Revocable Living Trust, there's no probate court involvement. So the clients keep complete control over what they have. While either one of us is alive, if it's a husband and wife, they designate who wraps things up on their path. And they state who inherits what between children, grandchildren, charities like the Mackinac Center. In the event of their death, complete privacy is maintained because nothing's filed with the probate court. Complete flexibility is maintained because they alone control their affairs while alive. And although there are time delays involved in probating estates, those are short-circuited with a living trust. Without the living trust, probate gets required if a client dies owning an asset in their own name. So we have some clients that think, well, that's easy. Just don't die owning something in my own name, and there's no probate. That's what the living trust accomplishes. It's not technically in their name. It's in the living trust, but it's theirs. They do what they want while they're alive. The problem comes up occasionally when the clients say, to avoid probate, I'll just add my kids' names to all of my bank accounts and other assets. And routinely, we get calls from clients who have done that and find out that their child is getting divorced. The soon-to-be ex-in-law is trying to claim ownership of that joint account that her husband or wife's name is on, or that the husband or the daughter or son had financial problems, and there are now credit card company liens on the account or IRS liens, or the big one I had. I still remember it. The lady called me one morning and said, I just wrote a check to Myers, and they told me that the check bounced. I said, oh, okay. How much money is in that account you wrote the check on? She said between $70,000 and $80,000. I remember thinking, wow, I only thought my wife knew how to spend that much money in one trip to Myers. But what happened is when I drilled down on it, I said, whose name is on the account? And she said, well, I have my kid's name on it so that they can help me pay bills. What happened, unfortunately, is that the one son, she had a son and a daughter, The son knew his name was on the account and, unbeknownst to the client, withdrew all the money. He was a co-owner. Credit union didn't stop it. So when I say that it's important not to give up control while you're alive, and the living trust accomplishes that, there's all sorts of cases we've had over the years where the do-it-yourself methods to avoid probate might work occasionally, but the lawyer gets called when they blow up, and joint ownership of assets is clearly a loss of control that has harmed many a client.
So Greg, you've actually started touching on one of our first audience questions, which is, can I add my children to my bank accounts or other financial accounts now? So that's an interesting cautionary tale, but can you give us a little bit more depth into whether they can or should do that?
Right. I didn't go through all the problems of joint ownership, but I'll give you another common example. So let's say that the widow lives in Midland. She has a son that lives right next door, but the rest of her kids are scattered around the country. She dies. The kids come in for the funeral, and they're sitting around in the house they grew up in and say to their brother, well, we knew mom had some bank accounts and she owns a house. Let's divide everything up equally so we can get on our plane and get back to our busy lives. And the son that took care of his mom said, wait a minute. My name was on those accounts. Those are my accounts. And the other kids say, well, we know your name was on, but mom only did that so that you could help her pay bills. It was a convenience account. She really wanted us to share alike on everything. And the son that lives next door said, are you kidding me? Called mom once or maybe twice a year, never came home. She wanted me to have this for all the extra work that I did for her. So we get about a half a dozen cases a year, joint bank account disputes. And the presumption under Michigan law is joint bank accounts are the property of the survivor. So there's no assurance in making an account joint with a child that if your intent was that it was a convenience account, that it will be shared among all of the children.
Greg, we're still getting a little bit of feedback. I don't know if maybe you're logged in twice or if it's through your phone and the computer. I'm going to hand things over to Lawson. And Lawson, if somebody already has an attorney or a financial advisor, can they still use a donor-advised fund as part of their plan?
The short answer is yes. I'll answer sort of the attorney question first and the financial advisor second. So you have to think of a donor-advised fund sort of outside your testamentary documents like wills, estates, charitable remainder trusts, charitable lead trusts, that sort of thing. And what I mean by that is that those documents require an attorney both to establish and, if and when you want to make changes, to make those changes. Changes, however, that you make to your donor advised fund account in terms of your intent statements and legacy planning, et cetera, do not require an attorney at all. So if, for example, in your will or charitable remainder trust, you designate a cash amount or a property or something to your donor advised fund account, you just work directly with a donor advised fund provider to put in place what in fact you want done with that if you've not already done so. And if you change your mind, you merely contact the donor advised fund provider and make this change. This happens with us all the time. All of our clients have an intent statement. We go through through them annually. We had a particular individual who cared about a particular organization solely because of the person who ran the company. They were that nonprofit. They had a special relationship, and so when that person left, he realized that if I was to follow through on his intent, I'd be making grants to that group. So he called and said, "Hey, would you please shift it to number A to B?" And it was done. So no lawyer was required. On the other hand, when it comes to the financial planner, many people have a very strong relationship with financial advisors. And so DAF providers do make it possible for a third-party financial advisor to manage the money that is in that donor advised fund account. Now, you as the account holder cannot manage it on your behalf. It has to be a third party that does it because of the ownership control issues. So we have several accounts where the advisor has recommended that we hire a financial advisor to make recommendations on how the assets in that donor advised fund account should be invested over a certain amount of time. And this is important because one of the benefits of a donor advised fund, especially as Greg alluded to the fact that, everything can change in November when various people are elected. The government gives and the government takes away. So one benefit of a donor advised fund is you can make contributions now, take the tax benefits now, and decide later how and where and when and how much you want to be sort of giving or recommending grants to various groups. So when you have for example, a financial advisor who's linked with your account and you have a multiple year plan, you want to leave X amount of dollars over X amount of time. Well, one of the benefits is that charitable account can grow and that money becomes more money for that charity. So think about Mackinac. If you make a cash or a stock gift to Mackinac, the odds are they're going to sell it very, very quickly because the cash is what's important for their operations. Donor advised fund, it isn't always necessary to sort of liquidate stock. It's going to depend on the provider's rules. And so you can also use that stock with the financial planner's advice to grow that account and have a much larger gift available later on. So both work, lawyer not as necessary with the DAF.
Got it. So Greg, if a client's heirs sue to challenge their estate, what can they do now to prepare for that challenge down the road? Just try to head that off at the pass.
There's a few things they can do, Joe. One is to start the estate planning process younger rather than older. There's no question about whether they had the capacity to do the estate plan. They could also have the estate plan reviewed periodically to reinforce their intentions. They shouldn't try to draft their own document. The bottom line on that is that estate plans can be challenged either because a client lacked capacity to know what they were signing or they were being unduly influenced by someone that stood to gain. In order to avoid those two claims, attorney-prepared documents would go through and minimize that risk. And we would also consider including a non-contestability clause. So if somebody does challenge the estate plan, they're disinherited.
That brings us to some of our audience questions. And in case there's some questions that pop into your head after the presentation, just feel free to email them to me at milligan@mackinac.org. That's MILLIGAN @mackinac.org. And the first question I want to ask to both Greg and Lawson. Greg, what is the difference between a will and a trust, and is one necessarily better than the other?
They usually are used in concert. So the main document that says what happens with the client's assets in the event of their passing is the revocable living trust. It's important also that to avoid probate, assets such as houses and financial assets are properly titled in the living trust. Not retirement plan accounts, but traditional brokerage accounts and other investments. Then you have this belt and suspenders approach. You also have a simple 3-page pour-over will that says if the client dies owning anything in their own name, it pours into the living trust on death. So the 4 main documents for a client would be the pour-over will, the living trust, and then 2 documents we haven't touched on, but financial and medical powers of attorney. And the pour-over will and the revocable trust go hand in hand with each other.
Lawson, do you have any other context to add to that?
No, when someone gives the right answer, there's no reason to complicate it by just talking. So Greg was spot on.
Absolutely. Well, Greg, that leads into another question, which is what happens in Michigan if you die without a will or estate at all?
Okay, so under Michigan law, there's a common misconception that if you die without a will, everything goes to the state of Michigan. That's not true. If you die without a will, you're said to have died intestate, and assets that you own pass by intestate succession. And what that means is there's a grid that you follow where you look at who survives the client. If the spouse survives and children of that marriage survive, there's an allocation between the spouse and the children of the probate assets. If there is no surviving spouse, but there are parents and children, there's an allocation between the client's parents and the children. Importantly, these just apply to probate assets. If the client owned assets jointly with another person, those pass automatically by joint ownership. Or if there are beneficiary designations on life insurance or qualified retirement plans, then those pass by beneficiary designation. Otherwise, though, the estate would be probated, and it would be probated under the laws of intestacy, meaning since the client didn't have an estate plan, the state has written it for you effectively by saying, here's who inherits what you have.
Lawson, I think we touched on this a bit earlier, but just for clarity's sake, can a person have both a living trust for part of their assets and a donor-advised fund for the rest of their assets?
Yeah, the simple way to think about it is a donor-advised fund can sort of play a charitable hub role, meaning you have all these disparate pieces of planning, really depending on what your goals are. Do you want to be building a charitable bank account? Do you want to develop an income stream for yourself? Do you want to be shifting wealth to the next generation? Do you just want to leave money to certain charities? Do you want to protect it from the government, et cetera? All of those, how you answer those questions determine the kinds of sort of legal documents they put into play. But with the DAC, we can sort of have pieces of that. So for example, the donor advised fund can be the beneficiary of your remainder trust when it comes to the charitable piece that you want. It can be the repository for some of the retirement assets. It can be the repository for a multiple year gift that you want to make as a bequest account. It can sort of manage, there's some legal issues we have to deal with, but if you're making pledges, it can become part of that. So the reality is that, yes, it can play all these pieces. So it's all complementary to one. And because, again, changes that you make with your DAF don't require the attorney, it's easy to set it up. So my mother, for example, in her fairly straightforward trust, rather than saying, I want to leave X amount of dollars, or better yet, a percentage to charity A, B, C, D, she literally has said, I want to leave X amount, or in this case, it's a percentage, to DonorsTrust. She has an account here. That's it. That's all that says in that legal document. Separately, she has on file with us what she wants to do with whatever that amount of money is, both how much, to whom, over what period of time, whether it's to be done anonymously, that sort of a thing. So there's an example of how they're collaborating together.
So if they set up a donor-advised fund, do their wishes take priority when it comes to where the charitable gifts go from that fund?
Well, I would say their charitable wishes take priority at all times, because that's the point of a donor-advised fund. Is while yes, there's the legal control issue that I mentioned. In our case, each of our clients has as detailed a list as we can get them to make. This is what I want to happen, both in the next 5 years, what I want to happen this year, what I want to happen 10 years from now. It can be as specific as you want. In fact, the more specificity, the better for us. And more importantly, I can get a phone call from a client that says, I actually have changed my mind. I want to do that. We encourage that review while you are alive, because obviously once you are not, we have to go with what we have on file at that latest period of time. But no, the wishes are obviously and always going to be paramount.
Sure. And the last question, Lawson, actually is my own, which is that you alluded to donor privacy earlier on as one of the advantages of donor advised funds. So just talk a little bit about why that is so important.
Well, it's an unfortunate reality that life is a little chaotic right now. And some of the passions that we are seeing and feeling, not just COVID related, but politics related to unrest in cities. And truth be told, there are plenty of examples of the last 5 to 10 years of donors who have essentially been outed, if you will, by making grants to organizations that were simply not popular with another subset of society. And states attorneys generals are trying to dig into, who are you giving to organizations in my state? I want to know who you are. This has been playing out in the political world, 501c4s, but it's spilled over to the C3 world. Donor advised funds, any donor advised fund, one of the benefits is a grant can be made anonymous. So I may get a recommendation to give $5,000 to the Mackinac Center. You're going to get a letter from me that says this is a grant from DonorsTrust to the Mackinac Center. It's been recommended by an account holder. That's all I'm going to tell you. If you wish to have contact with that person, you can send me a thank you note. But other than that, we're going to keep it separate. On the other hand, that person may want me to disclose completely who they are and where they live. That's their decision. So these days, as we're seeing, I think, a real pushback against a lot of conservative-oriented donors, the protection of donor advised fund can actually be very, very helpful. We're seeing private foundations starting to roll over as well into a DAF account, both to preserve the legacy because they're concerned about the next generation, but in some cases, it's actually the privacy issue.
That's great. Lawson, thank you so much for joining us. Greg, thank you for joining us. Thanks for the great conversation, guys. Again, if you have any more questions to ask that come to you later on, feel free to email me, milligan@mackinac.org. We'll be very happy to get those answered for you. Please also check our website for future events, mackinac.org/events. If there's something you want to reference from this later on, this is recorded and we'll have it posted up on that website as well, and you'll be able to check it and look back. Joe, Greg, Lawson, thank you again so much. Our audience, thank you so much for being a part of the work that we do as an organization, and we look forward to seeing you guys next time.